So tips and traps. 1, clearly limit the extent of your duty. And when I talk about clear, we're setting clear lines as to what's being done and what's not being done. When we're setting out what's being done, we're telling the clients the limitations relating to that work. On the issue of proffering advice, what we should be doing in the conveyancing process is providing the client with information, documentation, etc. Information is the conveyancing process, explanation, what it actually means, what the significance of the contract is, the significance of signing it, the significance of the mortgage deed, significance of signing it, etc., etc., and then advice. And really what we should be doing in connection with advising clients is highlighting to clients risk. So let me just give you 1 or 2 examples what I mean by that. If we're acting for a buyer, I think it's important that we say to the buyer, there is a risk, no matter what, that no matter how safe we are, no matter how many checks we do, there is a risk that the seller client is a fraudster. And if that is the case, if we pay over the purchase price to the seller, there is a risk that the seller disappears with the proceeds of sale and you do not acquire title. That's a risk. The assessment of what the risk is, impossible. What we can say to the client, if you're concerned about this risk, we can take out an indemnity policy that will provide you with cover to cover any loss that you sustain in the event of the seller being a fraudster. Now, I'm not saying you mention that to every client, but where you've got a client that's risk averse, where you've got some suspicions with regard to the seller, perhaps the seller is an international client or something of that nature, and you're a little bit concerned of the risk of property fraud, you can highlight the risk to the client and tell the client what can be done. Co-ownership. There is a risk with regard to a joint tenancy that the clients don't understand what survivorship is, don't understand that a joint tenancy can be unilaterally severed. So again, it's important that the client is aware of that risk and aware of what steps or measures can be undertaken to protect the client from that risk. With regard to a joint tenancy, we can't stop a fellow joint tenant from severing the tenancy. It might be appropriate where a client is concerned about that would create a tenancy in common from the start. Where a tenancy in common is created, it's important that the client understands that the deed of trust or land registry form JO, or the transfer, will be the document that the court will utilise to determine the extent of the beneficial interest between the parties. And therefore, where that beneficial interest varies, it will be necessary for the deed of trust to be reviewed. Clients need to understand the risk associated with searches and the fact that searches could be defective. The risk associated with a seller inaccurately or negligently or fraudulently completing TA forms, and the client then being potentially faced with bringing in action for misrepresentation in order to seek redress, with all the risks associated with that. So, important that we understand that our job is to provide advice that's reasonably incidental to the task in hand or required as per our retainer. On this issue of what's reasonably incidental, there's a concept called the adjacent tooth principle, which applies to dentistry. The principle applies to conveyancing. If I go and see my dentist and I tell him about a particular tooth that's causing me some discomfort, the dentist is required to look at that tooth. If, however, he sees an adjacent tooth that also requires treatment or some form of attention, he or she is on a bound to tell me about it. Well, the same principle applies in a conveyancing transaction. So although we've said what our retainer is, there may be other aspects of the conveyancing transaction out with the retainer that are reasonably incidental to the conveyancing process that require us to tell the client about it.